So apparently, although it says we're live streaming, we're not. So, but just act as if you were, because it says we are, but it's not going through the website. They're still working on it. But just act as if you were live. We shall all endeavor to be better at Zoom than Jeffrey Toobin. All right, well, it's not on the website. How long do you want us to wait? How long should we wait?
Hold on 1 second. We can start. It's just that the links aren't live on the website. So, but we can go ahead and go, and this will be recorded. And I think if folks go to YouTube and search for MGA Judicial Proceedings Committee, they'll be able to see that we're live. It's just the streams aren't up, the links.
Okay, great. So let's just get started because I want to give people ample time to get here after we finish. So this should only take an hour, but I wanted to make sure we just refamiliarize ourselves with the bill and then had an opportunity to go over at least one of the 4 components. So obviously, lengthy bill, it's 11 pages and essentially 4 components. You've got use of force, duty to report, duty to intervene, and then whistleblower protection. So I'll ask counsel kind of, let's work backwards, start off with something, the easiest concept to kind of understand and plug in. And so we'll just start off with whistleblower protection. It's also be important because of the conversation we had last week. So I think there's some overlap there as well. So let's start off with whistleblower protection, if we could, Jamie. Cleanly shaved Jamie right there. And so we'll start off with you and we'll go from there.
Thank you, Mr. Chair. So we're working off of amendment. It should have had a link to it in the email that was sent out to everybody. This is Amendment 878772, and this incorporates provisions of a couple of different bills, including, as the chairman noted, whistleblower protections. And if you turn to it's the page after bill page 11 of 11 in the reprint. This is where the provisions for whistleblower protections come in. And at the bottom of the page, so this would be the new section 3803, provides that a supervisor, an appointing authority, or the head of a law enforcement agency may not threaten or take retaliatory action against a law enforcement officer who discloses information that the law enforcement officer reasonably believes evidences either an abuse of authority, gross mismanagement, or gross waste of money, a substantial and specific danger to public health or safety, a violation of the law, or following disclosure of item 1 seeks a remedy provided under the subtitle or any other law or policy governing the law enforcement agency. So there's also a provision going into the next page that provides for disclosure of confidential information to the Attorney General. That's the subsection B. So if the disclosure is somehow otherwise prohibited, it could be made to the Attorney General if it's in writing, and also contains the date of the disclosure, the name of the law enforcement officer making the disclosure, the nature of the alleged violation of law, abuse of authority, management, waste of money, or danger, and if possible, the date or range of dates on which the alleged violation of law, abuse of authority, management, waste of money, or danger occurred. So that's just a very quick overview of the whistleblower provisions. And Mr. Chair, if you'd like me to continue on with the rest of the bill, I'd be happy to do that, or it's up to you.
Let's pause here and just see if there are questions or anything we can discuss. So I'd like to just take it piece by piece. Senator Hedelman has a question.
Thank you, Mr. Chairman. I just have a quick question. Are there any time constraints on when this can happen?
Specifically going to when the disclosure can be made, or like a set number of days that
Yeah, or is it open-ended?
Right, I don't believe so. I think it's more open-ended.
Okay, I didn't see any, but I just want to make sure. Okay, thank you.
Don't we have the standard statute of limitations of 3 years? This isn't a criminal, wouldn't be a criminal case. So in civil actions, it's normally a 3-year statute of limitations unless otherwise provided. Isn't that right?
So I'd have to look into the applicable statute of limitations, but I think you'd probably be right, Senator, that in a civil action being brought for damages under the new subtitle, I believe it would be 3 years.
All right, excellent. Senator Carter. Oh, there you go.
Thanks, Mr. Chair. And Roman numeral 3 of this section, a violation of law. My question is, should it be limited to a violation of law, or should it say a violation of law or policy?
Right, I think that was copied directly out of the corresponding Senate bill. I don't have the number in front of me, but I'll take a look to make sure that the language conforms, or just highlight it as a potential issue to bring up again.
Let's definitely track that down. Further questions from the group? Senator West.
Thank you, Mr. Chair. I'm just reading through this amendment, and on, well, there's no number of the page, but it's in section 3804 and 3805. 3804 says, in a civil action brought against a law enforcement agency, a law enforcement officer aggrieved may be awarded damages in the amount of $5,000 for each violation. So it seems to be a unilateral right to file a civil action and obtain $5,000. But in 3-805, down in subpart C, it says, in a civil action brought against under subsection A, the law enforcement officer may seek, instead of reinstatement and back pay, statutory damages in the amount of not less than $5,000. They seem inconsistent, aren't they? C, the second one I read, looks like you get to choose one. Either apply for reinstatement, or you can ask for $5,000. But up there in 804, it looks like you have the absolute right to ask for $5,000.
So under 3804, Senator, what that's pertaining to, those violations under A and B of 3804 pertain just to the law enforcement agency's failure to provide a copy of the subtitle to the officer.
Oh, okay, fine. Sorry, I missed that. as I said, I'm reading it for the first time.
So if basically under A, a law enforcement officer could request that they get a copy of the subtitle. And under B, if there's an allegation that there's been retaliatory action, the agency is required to provide a copy of the subtitle. So, right, those violations would just be for a failure to provide those.
It's sort of weird. The subtitle would be available in the Maryland Code. Anybody could look it up online. I'm not sure why somebody would be entitled to get $5,000 because the agency didn't provide them with some of the document that the person could have gotten online. But is there a rationale for that?
Senator Carter.
Thanks, Mr. Chairman. So I think that it's open, should probably be open for discussion if we think the penalty is too great, but I can speak to the rationale behind it, which is that one, it's kind of parity because right now police officers are expected to read their policies online, their updated training, they're supposed to keep up with that. And if they don't do it, they are amenable to repercussions, penalties for not so doing. I think that this language comes from the legislation as I initially proposed it. And I want it to be clear that the agencies had the responsibility at the beginning of a law enforcement officer's hiring and period of service, that upon hiring and upon that initial training, they make it clear to the officer that you will be that misconduct is not tolerated. You are required to report it and intervene when you see it. And if you do, we guarantee that you will be protected. I think it was to make it clear that to sort of ensure that they would know that this is the policy of the agency, because many officers back, I think it was like so long ago, I can't remember, so many years ago when this bill was first proposed, testified about the fear of retaliation. And then there were so many examples given about it. And so in my mind, to alleviate that concern, the agency would proactively and assertively state to the officer at the beginning of their term, this is our policy. We guarantee you'll be protected and we won't retaliate. We won't tolerate retaliation. So I don't want to ramble, but I thought it was a good idea.
It seems to me it's a good idea to require the policy provided, but the idea that a policeman who didn't get the policy handed to him or her would file a lawsuit, go into court, get a lawyer to prepare a complaint, go into court, file a lawsuit, and ask for $5,000 damages because the officer didn't get the copy of the document that's available online. It seems excessive. I don't know why we need the penalty section. That seems to me the first two sections saying the police agency has to give it to them should be sufficient.
I think that, again, that the reason was that extreme level of fear that officers stated that they have, and the culture of silence that is promoted in the agency and the culture of retaliation that often exists is the reason. And so we can discuss maybe there should be a lesser sanction, but I think that the point of it was to make sure that officers were advised of it and they were made to feel comfortable at the very beginning of their service. It's more than just, this is our policy. It's, we want you to understand that this is the culture within our agency and giving them a sense of security. And also think about, a place like maybe Pocomoke City or something like that, the friendliest town in America or Maryland or whatever it says it is, where there's this small town and very, very insulated police agency, some argue working in, not very transparent place where you want officers who may not be as aware of what the state of Maryland's laws require, that we want them to be forced to give this information to the officers and make sure that they're clear. That's all. So maybe the penalty is too much, but I do think it was done to ensure that it was done and not done like reluctantly, not done, in a way that was like, here's the paperwork, but really done to say, look, this is our culture. This is what we're coming into. We don't tolerate this kind of behavior. And we want you to know that you're protected. Like, we're on your side. If you report misconduct, we're not going to support the other way, which is.
I don't want to belabor this. This is
Me neither.
It's my guess is the Fraternal Order of Police will inform the officers that are members of their organization that they have rights in case of retaliation. So I suspect the officers will not be unknowledgeable about their rights in this respect, but we can talk about it later.
Really quickly, it's not so much a matter of them not being knowledgeable. It's the fact that in the past, it hasn't been emphasized in officers, because this has already been in law before, but it wasn't something that was emphasized to officers. And those officers that have been in great fear of retaliation, I felt that they needed a little bit more support.
Okay.
All right, let's keep moving on. No, I definitely agree with Senator Carter. You definitely have that some teeth for enforcement. I don't know what that is, but I think you definitely have to have that incentive. All right, looking around, further questions? All right, great. So then, Jamie, let's move on. I mean, we'll obviously explore this a little bit more, but let's move on to duty to intervene.
So on page 7 of the reprint, there is duty to intervene and also duty to report. Now, duty to intervene actually was included in the bill as introduced. So provisions of that were made consistent. I believe later there might have been something. It's been a while since I drafted it, but in the penalties provision that needed to be changed to fit with duty to intervene. But basically, the duty to intervene is under 10.803 on page 7, and it provides that a law enforcement officer who knows or reasonably should know that another law enforcement officer is using excessive force or intends to use excessive force shall make a reasonable attempt to intervene to terminate or prevent the other law enforcement officer's use of excessive force. And then the duty to report comes immediately after that. A law enforcement officer shall report the conduct of another law enforcement officer to the reporting law enforcement officer's supervisor or the chief of the law enforcement agency that employs the reporting law enforcement officer, if the reporting officer has actual knowledge that the other law enforcement officer has engaged in, and there's a list of violations, and that includes homicide, the use of excessive force, a sexual crime, theft or a related crime, perjury, fraud or a related crime, or tampering with or fabricating physical evidence. Violation would be subject to the penalties provision found on page 8 of the bill under 10.805. And that would be for a law enforcement officer who recklessly fails to act in accordance with the subtitle. That would be a misdemeanor subject to imprisonment not exceeding 5 years. And for a law enforcement officer who knowingly and willfully fails to act in accordance with the subtitle, that would be a misdemeanor and imprisonment not exceeding 10 years.
All right, discussion. Senator Bailey.
Thank you, Mr. Chairman. If we could go back to page 7, 10803B, and I just would like to know when we read that a law enforcement officer who knows or reasonably should have known that another law enforcement is using excessive force or intends to use excessive force. How do we know, how do I know that somebody intends to use excessive force? What is the actual legal definition for that intends to use?
Thank you. I think that an example of it would be, you know, hey, I got a monster, let's go get him. You know, oftentimes officers state what their intention is to do, and the officers that are around them know exactly what the deal is. So I think that that would be an example of when an officer is there and knows that their partner or person they're working with intends to do something that's inappropriate. No one is saying that they have to read the mind.
No
or
idea what
the brain of another officer, but certainly if there is an indication that something's about to go down that isn't appropriate, they would be able to do something about it without other than participate.
Senator, I have no idea what you're saying. So if he said he's going to go lock somebody up, you know, they're a criminal, and he says, well, let's go lock him up. So they intend to go lock that person up,
No,
right?
I mean, like, let's go jack him up. There's a black guy with a knapsack walking down the street. Let's go jack him up. That would be an example.
What does that mean?
Let's go accost him. Let's go push him to the ground. Let's go illegally search him. It could mean a number of things. I mean, maybe I shouldn't have used that term, but that's the term that I've known officers to use, that kind of language and other.
Well, I'm just saying, I worked 30 years doing this. I have never heard somebody say, we're going to go jack him up.
Oh. I don't want to say I don't want to say another word that is used. So I'm trying to think of something, you know, less offensive to people.
Okay. So just based on somebody what they verbally say, right, and they could be upset, excited, whatever. They make one word comment, you know, like that would be grounds for a violation of this?
Could be. I mean, it depends on the circumstances, certainly. But, you know, many times, as we saw with officers that have been part of units that have routinely violated the law and policy, there has been collusion. And quite often, when they knew that they were going to, for example, illegally go into someone's house without a warrant and steal from them, it was the kind of situation that the officers that were there knew exactly what was going on. So in situations like that, they would be aware of the intention. For example, going into a house without a warrant, you know that you're requesting a warrant, and if you are requested to go along with someone to do that, then you know that they intend to violate the law.
No doubt about that. Senator, I completely agree with you. If you had knowledge that they were going to go commit some type of criminal activity and in the performance of their duty, and you were going along with them to do that, where they plan to go break into somebody's house, something in that scenario, I totally agree that somebody could say, wait a minute, he definitely intended to break the law. But just on somebody saying that he's going to go, and to use your terms, we're going to go down there. We're going to find everybody that's there. We're going to jack them up. Right. That alone, if that person, you know, I don't think that is an element of a crime that we want to say, well, all of a sudden, yep, he said he was going to jack him up. Right now, officer, you're facing this thing. I think that's quite a stretch. And I think this part, this intends is something that we probably would potentially need to work on.
If you and I are partners and we're having a slow day and we're sitting in our police car, drinking coffee and eating donuts, for lack of a stereotype.
I was going to say, here we go.
But they're Krispy Kreme, not Dunkin'. And so, you know, we're having a slow day and I'm like, hey, look over there. You know, there's a black kid with a backpack, which is, I say that because that's a common prerequisite for officers to decide that they are going to stop and frisk and accost and often illegally search young black men when they see a black man with a backpack. So I say, hey, there's one. I see one over there. Let's get him. What do you think that means? If there's no other indication that criminal activity is afoot, but I say, let's get him. What do you think what would you think I meant? I'm just asking. Let's get him. Let's go get him. Let's go, let's roll. But we haven't seen any evidence of criminal activity. I would say that would be an indication that I'm about to do something wrong.
So I would say that you know, very fortunate for me, I guess I've never had that happen to me, and I have been with a lot of different partners over a lot of different years, and I have never seen something like that play out. Now, if you know, obviously, if there was a situation where somebody went to do illegal activity, I think at that point in time, definitely, I think there is clearly a role that an officer plays when that activity is illegal, that the officer needs to stand up and stop that activity and move forward and say, wait a minute, right? There are definite rules of engagement that need to be followed when you are working, no matter what activity you're working on. But the point that I was getting to was just the fact that somebody was having a conversation and they said something, because, you know, in life, I have known people that, you know, used wrong terms. They might have exaggerated, whatever. That fact, when they, just by simply having a verbal conversation, I don't think that is where where we should be. Well, he definitely intended it, because that's what he said this word, right? And I think that is definitely, I mean, I think there's much more when we talk about you know, working into the actual intent of the crime. They said something other than just saying a word. I mean, when you clearly, if you and I were sitting in that car, I mean, if I wasn't done my donuts, I might say, hey, wait a minute, we're not ready to get out of here yet. But at the same time, I would be like, well, what are we doing? Why are we going to go get that young man with that backpack, right? What has he done wrong, right? What are we doing here? And we can have a simple discussion back and forth. Quite frankly, that actually exists quite often when you're fortunate enough to have a partner. You know, a lot of policemen in this state don't have that opportunity. But when you have a partner, right, you should be bouncing things back and forth because when you're out there on the street, things happen extremely quickly. If you see somebody that has taken the law in their own hands and they're doing things you know, in excess or too much, or obviously committing a criminal activity, criminal act, you have to stand up, right? So there are definitely parts of this bill that you and I are clearly going to agree on. But I'm just saying on the bare word, before any other activity comes in, that they're guilty of the same amount of penalty as if they were. And that's just something that we just need to discuss. I just was trying to get the intention of the words here.
Right.
Thank you.
Thank you, Senator Bailey. Thank you, Senator Carter. I kind of, I read it again as well. I had the same concerns. I mean, my initial thought was it was something like, well, I'm going to go put my knee on that person's neck, or you see an officer using disproportionate force for the situation. That was kind of like what came to my mind. But it's clearly, it encompasses more than that. So I don't know how we limit that, but that'll be our work moving forward. Okay, Senator Jackson and Senator West.
Thank you, Mr. Chairman. A question for, I guess, just a directive statement to the maker of the bill. Well, before I get there, not all of us drink coffee or eat donuts. So, just saying.
I'm getting hungry now. That's all I know.
But so in 10805, we spoke about this before. I think in the initial hearing. My challenge, Senator, has been and will continue to be the penalty phase. I think we have a system established to penalize anyone who engages in such actions. So I have a challenge with, I guess it's C1 and 2 regarding the penalty phase. So I'd love to have further conversation with you as we move forward with this bill. I just think that there are already provisions that are there. There are internal administrative policies and procedures that officers are supposed to report misconduct by fellow officers. Now, in cases where that doesn't happen, there are internal remedies, and if it goes too far, our prosecutors have remedies for that. So just wanted to record that.
What was your Senator? Well, go ahead. Sorry, Senator Carter, go ahead.
I was gonna just basically respond with the data bears out that something like less than 1% of cases with officers are ever criminally prosecuted, and that all of the information we have from various internal affairs complaints indicates that administrative remedies have been rarely, if ever, result in sustained findings. And so I would be adamant that we would join the 41 or so other states that have use of force law that has civil and criminal remedies within that law. We are in a minority of states that does not do that. And the other states that have done it, I would also suggest, and we can definitely argue about this, that we, based on our data, our evidence, and the atrocities that have happened routinely over decades in Maryland, we should join other states in trying to ensure that we send a strong message to law enforcement officers about what their duties are, and if they violate those, and a human life is harmed, a human life is taken, that won't be something that can simply always be dealt with administrative remedies when the behavior rises to the level of criminal activity. That's all.
No. And trust me, I certainly understand, but I am certainly about accountability. And I didn't mean to imply, if that's how it came out, that these remedies are for administrative procedures only. That's not what I meant. And again, if something's happened that's criminal, that occurs before any administrative hearing. So that's not what I'm saying. My concern is that we are putting into place criminal penalties that are already on the books. And so that's my concern.
Senator Jackson, I was going to ask you, what were the policies? Obviously, it's not a uniform across the state, but what were the policies for failure for the duty to intervene within your department? What were the penalties?
Well, I mean, look, it's I don't think they were specified back then, but if there was a crime committed by someone on your squad or someone on that scene, everyone would be subject to an investigation by the state's attorney's office. and then through the administrative, the agency. I mean, you have a right to, or you have an obligation to report a crime. I mean, that's your job. You're a public safety officer. And so, look, I understand, again, we have to reform and we have things to address. But I think, I truly believe that there are laws on the books that says if you are a party to an event that is deemed criminal, then, our system has ways of taking care of that. So.
All right, Senator West.
Thank you, Mr. Chair. I think what Senator Jackson just said, it certainly resonated with me. But the reason I raised my hand was to respond to Senator Carter's hypothetical. If I'm sitting in a car with another officer and the other officer says, see that black kid over there, let's go get him. This bill is all about excessive force. And let's go get him could suggest, let's stop him, let's frisk him, it may be that there's not probable cause for the stop and frisk, but that's a different issue than excessive force. We're talking about a bill here which comes with criminal penalties, 5 years in jail. So it seems to me we need to be careful about the hypotheticals we use, because under no circumstances would I suggest that an officer who didn't do something to intervene when words like "let's go get him" are expressed, should go to jail for 5 years. It seemed, to me, those words are consistent with a stop and a frisk. Maybe my partner saw something fall out of his pocket. Maybe there was some other indicia that would suggest that he should be stopped. But merely stopping somebody is not the use of excessive force. That's my point.
Thank you, Senator West. My scenario wasn't involving the officer contending that they saw criminal activity afoot. I specifically said where there's no indication that there's criminal activity afoot. My counter to what you suggest is that under the Constitution, stopping and frisking people is unconstitutional, thus a violation of the laws of our country.
I said that may be the case.
In addition to that, to sit there while my partner says, let's go get this person because they're black, in addition to the fact that it's unconstitutional, it's racist. And that's the type of culture that we definitely want to try to, change, because we know it does exist now. And so my argument to you is that, just because you have the concept that is in the bill that someone intends to commit excessive force or whatever, doesn't mean that that's what is happening. It's just like anything else. It would have to be determined that that's what happened, that you knew that this person was going to commit this act. It's not as if you can speculate, for what you said, if you were just used to sitting in the car with your partner and it was a pattern to just go, frisk black kids and steal whatever money they might have, I would argue that should also be something that's reported as a violation of law and policy. It may not be part of the force, but it's something that should definitely be a duty to report, which I do think is covered under the bill, is duty to report. Well, I mentioned it early, violations of law or policy.
Right, we're going to get into that. My point was just that there is a real distinction in my mind between racism on one hand and a violation of the probable cause rules and excessive force on the third hand. This section of the bill is all about excessive force. We should not let that leak into a lack of probable cause or racism, however racism is defined, or we're going to get ourselves into trouble here. It needs to be narrowly drawn. It's a criminal bill. It needs to be narrowly drawn.
Okay, thank you both. We'll move on to Senator Sidnor has a question or a comment. You're up.
Thank you. As I listened to the discussion, I just wanted, I think maybe Senator Carter should have stuck with her first example of let's jack him up. Now, I think what she was intending to do was to try to provide a better idea for those of you who don't know what she meant when she said jack him up. But if you are saying to someone, let's go jack somebody up, that the intent is there. And I think we're acting pretty naive if we're trying to act as if we don't understand what the language is. And I think she's been right on point. Maybe let's go get him. It could mean a bunch of different things, but I would assume that in looking at the totality of circumstances, and if she was to go beyond just those words, it's not going to be, okay, let's go lock him up. Let's go arrest him. Let's go get him. I think in her mind was meaning let's go hurt the person. That's why her first example was let's jack him up. And for me, your intention or your words are certainly great evidence of what your intent is. And I think again we're acting obtuse when an officer or anyone else says something, you take them for their words. So I just wanted to leave it there.
Excellent. Thank you, Senator Sidnor. I was going to ask for counsel to come back on, but if we could get a kind of a crosswalk of, you said that Senator Carter, at least 14 other states, how many other states had something like this on the books?
41.
41. Okay, wow. So I think we should, get some sense of a crosswalk of not only what the range of penalty is, but then also if we could have some sort of just background on what the policy reason was behind whatever penalty they put in. That'd be, I think, probably useful for us during the voting session.
Sure.
Thank you.
I'll make a note and get to work on trying to put something together for y'all.
And if the language was like as narrow or as, I don't know how to interpret this, whether it's extremely broad or narrow, but I don't know. We probably need to look at the intent piece very, very carefully as we move forward. But okay. Any other question, Senator Carter?
Thank you. I'm sorry about this, but I'm struggling to follow the bill and stay on the screen. And so I might be slightly missing the problem with the language. But I just want to say that, we deal with the issue of what intent is in many areas of the law. But when it comes to a duty to report, we have a standard, for example, with certain people that are obligated to report things. Like as an attorney, I'm obligated to report if a client of mine says, I'm going to go kill this potential witness in my case. So they tell me this, I know that's their intent, then confidentiality is done and I have a duty to intervene, report, and do something about it. That's what we mean. It's not really all that complicated. Maybe the language should be tightened up, but I think intent is intent. And we're able to interpret what that is in multiple other areas of the law.
No, it's a fair point. I think it's also worthy, if you're looking at a potential 10-year misdemeanor, that it's important to have the discussion, but it's definitely a good point. All right, moving along. All right, so Jamie, we're going to wrap this up, the next 10, 15 minutes here. So we can get one more done. If we go to the, so it looks like we've probably exhausted the duty to intervene. Everyone understands what that is. The duty to report, it should be pretty straightforward as well, but if we could just kind of rehash, have a little discussion there, and then we can kind of go to the top level use of force, which will be much more difficult than anything we've talked about so far. But go ahead.
So just one quick note before getting into the use of force, but I did want to point out that on page 11 of the bill, there is language that mirrors Senator West's bill on the adoption of rules by a law enforcement agency. So that's on page 11 of the reprint, the new section 3524. Requires the chief of a law enforcement agency to adopt certain rules to be followed by all law enforcement officers employed by the agency. So I just wanted to point that out. And then going to,
Just to be clear, though, that's nested under use of force. That's not the duty to. That doesn't.
Right.
Again, yeah, I don't want to. We'll open that can of worms in a second. Let's go to the duty report because it's a little bit more narrow. Then we'll move on to that.
so the duty to report requires the law enforcement officer to report the conduct of another officer to the reporting officer's supervisor or chief if the reporting law enforcement officer has actual knowledge that the other law enforcement officer has engaged in any of the conduct described on page 7. So that's homicide, use of excessive force, a sexual crime as defined in Title 3, Subtitle 3 of the criminal law article, theft or a related crime in violation of Title 7, Subtitle 1 of the criminal law article, perjury as specified under Title 9, Subtitle 1 of the criminal law article, fraud and related crimes, again, cross-reference to Title 8 of the criminal law article, and tampering with or fabricating physical evidence in violation of that statute under the criminal law article. And I'll just quick note, because the penalty provision applies to the entire subtitle, the same penalty structure would apply to a law enforcement officer who violated the subsection.
All right, discussion, questions, comment. Hey, Jamie, here's a weird question for you. The way that it's drafted, I mean, I guess that would, so if it's like, I'm thinking about like just a timeline, and I mean, I guess the way this is drafted, like a contemporaneous observation of something like this happening to report that. I mean, by the time you report it, it would be in the past tense. So I guess that's covered. But I mean, it's kind of a weird, I don't know, we'll talk offline, but the contemporaneous piece is what I'm kind of
that's a good question. And I guess the closest analog that I can think of would be the reporting requirement for child abuse and neglect by mandatory or mandated reporters. And I believe in that section, there is a timeline to follow. I'll have to dig into that a little bit more closely to see if there's something there. But as far as when one entity is supposed to submit reports, I do think that there is a little bit of timing language in there.
Okay, got it. I mean, it's small, but probably it could be significant. Okay, Senator Jackson and then Bailey.
So thank you, Mr. Chairman. So Jamie, you mentioned that the penalty is the same for the person who committed the crime as it is for the person who observed and failed to intervene.
So it really relies on a violation of the subtitle, and the penalties provisions are on page 8 of the reprint. So that's in starting at line 7. So this, off the top of my head, the closest mirror to this is in firearms. I believe, I forget if it's regulated firearms or another part of that, the public safety article. But basically, there are provisions in the code where, all of the penalty provisions pertain to the entire subtitle. And firearms is just the one that's coming to mind for me right now. But basically, any violation of the subtitle, which would include that duty to report, would be applicable, or those penalties would be applicable.
Senator Jackson, just read real quick. So just under 803, so duty to the duty to intervene and the violation of duty to intervene and duty to report are the same. It's not going to be the same as whatever the offense is, the underlying offense that's being the failure that the other officer is failing to intervene or report about. So it depends on what the other offense is. But I think if that's what you're parsing out, then the penalty is not the same as the offense that's being observed. That makes sense. It's just the same as, so it's just the duty to report and duty to intervene are the same penalties.
Right, correct. So if, right, a failure to report a first degree murder wouldn't result in
Correct.
incarceration for life
I,
without parole.
I am aware of that. So I think what I heard from you was that maybe I heard it wrong, but that's why I raised the question. So thanks. I'm good. Thank you.
Thanks, Senator.
Senator Bailey.
So that's exactly where I was. I had some confusion. I mean, quite frankly, this appears to me that you're either part of the problem or part of the solution. And obviously, if there's a homicide that's happened as a result of something to do with the use of force, if it was unjustified, I mean, clearly the duty to report by that officer, and we could what if these things to death, but sometimes the duty to report is right there at that point in time. I mean, if you see an officer that obviously makes clearly the wrong call and clearly violates criminal law, right? The duty to report is right then. And you're not reporting that to a supervisor. It doesn't matter what the rank is. Police officer is a police officer. You can take action against another officer at any time, right? That is the sworn oath that everybody has taken. I just have some questions as we move through this. Just that I will definitely get with for the intent of some of these questions. So thank you.
Excellent. Senator Castley.
Thank you. I'd just like to discuss for a minute the portion of the bill that's new or reasonably should know. And to use a really simple analogy, I'm an adult, I'm a parent, I'm home, I'm watching a 3-year-old kid, and I see him going towards the electric socket with a sharp object to put it in the receptacle, and I watch him. And I let him do it. He gets the crap shocked out of him. It maybe maims him or kills him. That's pretty bad on my account. I mean, that's like heinous. I deserve whatever punishment the court should give me. If I'm the same situation and I'm watching the kid, but I'm also sort of watching the football game and I don't really paying as much attention as I should, kid does the same thing. I reasonably should have known. I should have been paying more attention. I should have been a better parent. But there's a big difference between I sat there and watched this happen, I knew it, versus you really should have been paying more. I mean, reasonably, as a good parent, you should have been paying, you should have known that. But this statute equates the two. And I find the depravity in the first totally unmatched by the level of inattention in the second. And to treat those the same seems misplaced to me. I talked to my fellow officer and they clearly said that he was pissed off at that person and he was gonna go beat him up. And I went over with him and he just beats the stuffing at him. I can see he's not armed. I can see that he has no ability to fight back. That's I know. Now I was talking to some other people. I had called my wife on the phone after the arrest and I wasn't paying attention like I should have been. I reasonably should have been paying more attention. I'm not supposed to be on the phone with my wife while I'm involved on the job. I should have been paying attention to what my partner was doing. But we're treating those two the same. And yeah, I should be disciplined for calling my wife to talk about our date that night. I should have been doing that instead of, ignoring what was happening on the ground. But this treats those two the same. And I think certainly the latter merits whatever administrative penalty that the department wants to melt out. But the criminal sanction available in the first is certainly appropriate, but not the second. So maybe council would comment on that. Or the sponsor, I don't care.
All right, Senator Carter, our counsel.
Thank you. I would actually, Senator Castley, I liked your example. My argument for why I don't agree that it applies here is because I think there's a difference between the responsibility of a parent that should be overseeing a child and a law enforcement officer who is on duty, who is paid through taxpayer dollars, and whose responsibility it is to be paying attention while he's on duty. And so, you know, I do think there's a difference between I'm just neglectful and then I'm wantonly, willfully destroying, and our laws make exceptions for those, or they make distinctions between those. But at this moment, I'm not able to fathom. I just forgot to pay attention when I saw my partner beating this kid to a pulp.
That's not what this is. You're
At some point, you are aware of what's going on. Even if you weren't like initially paying attention, when you see, you're like, oh shoot, I didn't realize it was gonna happen. But at some point you do become aware.
Well, you just restated the entire, if I knew it, then I knew it. You're saying, well, you probably actually knew it and you weren't paying attention.
No, I'm saying you're on duty, and so you have an actual job to pay attention to what's going on. Especially when human lives are in the balance, when you're responsible, when your very job is, I'm here to protect people. I'm here to serve and protect them. That's my job. And then on my watch, while I'm being paid to serve and protect, this person is getting, eviscerated, getting beat up, getting destroyed. You think there's a responsibility more than just being a neglectful parent, because I think the duty is to pay attention.
Yeah. Okay. Maybe you just have a different view of parenting. I see, higher calls and demand and charge for more morally and legally than that a parent owes for a small child. But you keep giving examples that push us right back to no. You don't talk about reason. No, every example you give is, come on, he really knew. Okay, then he knew. So we get him under the no. But reasonably should know says he didn't know. The jury would have to say, no, he didn't know. He didn't know about this, but he should have been paying more attention. So you're imposing the same liability. And you keep falling back and saying, yeah, but it's appropriate because let's face it, he's a cop. He should have known. He knew. He was just kidding. He wasn't really telling the truth. But we're talking about the elements here. If he really knew, then he knew. So you got him on the first half. But the jury would have to say, no, he didn't know. But you know what? That's not a very good cop. He should have known. He should have been paying more attention. So we're going to give him 5 years for not being as alert as he should have been or she should have been. And I just don't know where we do that professionally anywhere else. I mean, doctors all the time commit malpractice. Not all the time, probably maybe more than police, but I don't know. Who knows? But we sue them and we sometimes pull their license, but they never go to jail for that unless they knew. I mean, if he knew he was going to commit malpractice, but they often are not sufficiently alert as the law would require, but they don't get criminal sanctions for that unless they knew. I mean, if he knew he was perforating that bowel, he's going to jail. But if he reasonably should have known he was perforating that bowel, that's called negligence, and he can be sanctioned. He can be fined, let go, privileges pulled, and so I'm just making that distinction. That's all. Thank you.
So, a couple of things. One is that we discussed the same concept a few minutes ago with the concept of intent, that if someone makes an overt statement or an overt act toward doing something, that should signify that they're about to do something. Even in the law, where it comes to negligence, when the failure to pay attention or the failure to do something is so egregious, it rises to a level beyond negligence under the law. It rises to a level of criminality when it comes to a gross or reckless disregard for human life. So that's putting that out there. It can rise to that level.
No, I realize that. I'm just sort of baffled by this whole distinction between police officers and the rest of humanity that we find ourselves in all these discussions. That here's what's fair for the rest of humanity, and then for those small minority who go into policing, we have a different standard. But I know where this is all coming from. So I'm, hey, what can I say about it? It's there. I mean, there's a gross bias in these bills that's clearly anti-police, and hey, we'll just deal with that. But thank you, I appreciate it.
Actually, I'm gonna really quickly. That's absolutely ridiculous.
No, it's true.
It's so many times because the good officers who are out there working as hard as you all believe all of them are going to benefit from this and going to be rewarded. And guess what's going to happen? We're going to restore trust in a profession where it's been lost, and we're going to restore integrity to a profession where now it's extremely questionable. So this is what we're going to do when we pass these laws. We're going to restore a profession that's been horribly damaged by bad actors that have run amok and not been held accountable. That's what's going to happen.
Or the alternative side. I mean, there are certainly different possibilities, but it's also possible that reimagining criminal justice will absolutely destroy public safety and lead to even greater harm to the very people who you're trying to protect, and will destroy an entire profession, and the murder rates will rise and the crime rates will rise. But this is what happens when we just use our imaginations instead of actually studying through these things, because I can imagine all kinds of stuff. And personally, I imagine a much worse world, particularly in the urban centers, when we're done reimagining criminal justice. But hey, you're entitled to do that. You brought the bills.
For the record, can I say one more thing? For the record, in looking at the language to put into this bill, I specifically looked at the Baltimore City post-consent decree language. Much of it was good. I specifically looked at language from a really good use of force statute in two other places. One was Camden, New Jersey, and other model language taken from the 41 other states that have a law. Okay, this is not willy-nilly. We are actually in the back, at the bottom, and when it comes to states that have taken this on. And the states that have done it, many of them have better policing.
Well, I'm anxious to see that, and I appreciate the chairman's decision to kind of quantify that. I mean, we're sort of making generalizations, states taking this on and that on, and we know from other bills that, you know, generalizing in these things isn't usually accurate. That we find that when we start saying, well, you're the bottom of 40 other states, and then you start parsing out the laws, the other 40 states are, you know, shocker of all shockers, have not adopted a uniform statute and looked at this uniformly. And so anyway, I look forward to the chairman's.
But this language was taken from other existing laws is my point.
Okay, thank you.
Thank you both. I mean, look, we're all here. We all agree that the systems can be improved upon, and once we do that, and if we do that, that policing will be more, the efficacy will be increased, and I think the security proposition for our state will be better. But all right, Senator West.
Thank you, Mr. Chair. I'm trying to figure a way to deal with the concerns that are obviously being expressed by several of us. What about in that section 10803B? Suppose we consider taking out the words "or reasonably should know." So just leave it knows. Clearly, if excessive force is being used, the other police officer is going to know that it's being used. And so that's not a problem. If if you're looking at the intends to use, wouldn't it be better not to include the language "or reasonably should know" that somebody else intends to do something? That's really, I suspect it'd be very difficult for any prosecutor to prove beyond a reasonable doubt that the policeman's partner reasonably should have known that his partner intends something in his mind, intends to do something. And I think that's what's giving us all pause. So if we took out "reasonably should know," just leave it as "new." So if the partner says, "I'm going to go beat that guy to a pulp, let's go," you know what he's going to do, right? You know, it wasn't words like what "jack him up," which I don't think I'd ever heard the expression "jack him up" before. But if he says, "Let's go out and beat that guy to a pulp," now you know what he's going to do. And you can penalize the partner for it. But reasonably should know that he intends to do something. I'm having a problem with that. And I think maybe we could reach some consensus if we took out those words.
So initially, I got to tell you, I mean, initially that's what that compound it baffled me too. Like, I was trying to figure out a way to get around it as well. And I think that you're right, especially the intent piece. I don't know, we'll see, and we'll talk more about it. But again, like I was saying, you know, if someone says, I'm going to put my knee on someone's neck, or if they use disproportionate force, like someone is unarmed and then they pull out a weapon and they escalate. I mean, those are things that you know that they haven't used the force, but they're intending to do it. So I'm clear with that, but I think it was the compound of the reasonable language and the intent that had me,
Used. Right. Yeah.
Okay. Senator Bailey.
So just and one other thing, I was sort of thinking while we were talking about this. Okay, so the one officer says, well, this is what the officer said. And so you have one that said one thing, you have one that said the other. Where do we go as far as you just have a statement by each one? And now when it comes in there, it's going to be a he said, she said. I mean, their conversations clearly are not taped. There is, so you have two people that are with opinions against each other, complete different stories. What are we going to do about that as far as proving one did the other? Now all of a sudden, now you've got two people that are like, well, we're never going to work together. So I do think it's important that there has to be something other than just verbal conversation, because of the different terms that are used mean different things to different people, unless it's clear, my opinion.
I want to go ahead and just close this up here, but I did. So I think this is very, very helpful for me at least. I mean, I've got some homework to do before we get back in terms of what the other 41 states do. The intent language, the new or reasonably new, or knows or reasonably know, should have known. So yeah, council, we've got a lot to work on, but this is great. I do want to give folks just some time before we have to reconvene for voting. So today we're going to vote on the body camera and the no knock. So we had pretty fruitful discussion last time, and hopefully it won't take too much time. I say that in jest, but too much time this afternoon. So, and then we'll turn back to the use of force discussion tomorrow. So I'll see you all in a few hours. I thought this was helpful. We've got some follow-up to do before we reconvene. So thank you all. See you later.